Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. I'm doing a series here on contract law, and this is going to be the first in the series. A contract is an agreement between two, sometimes more, parties that creates an obligation to perform a particular duty or to not perform a particular duty. A legally enforceable contract has the following elements. First, an offer to do something. I will plow your field this Saturday if you pay me $40. An acceptance. Hey, you've got a deal. Mutual consideration, which is the value received and given. In this case, the money that's paid and the field that's plowed. Those are considerations. And legal parties, meaning you can't contract with for example, a minor or an incompetent, and a legal purpose. You can't enter into a contract to break the law. I'm going to cover all of these topics, all 5 of them, in this series on contracts, but today we're going to start with a concept that even lawyers grapple with, and it's the element of consideration. It's a topic, as I said, that has frustrated lawyers and non-lawyers alike because often what seems like consideration is not, and what seems like it could not possibly be often is. Understanding consideration is a little bit like trying to nail Jell-O to a tree. In simple terms, consideration in a contract is something of value that is given by each party to the other. It's an essential element. A contract can't be binding without consideration. And it can take various forms, such as money, the $40 for plowing the field. Services, plowing the field. Goods, I'll pay you $100 for your armchair. But promises are probably the most frequent thing that are exchanged in contracts. Promises to do something or to refrain from doing something. Essentially, it's what each party is giving or exchanging as part of the deal. So this is the case of Catherine Jimenez versus Cintas Corporation. And Cintas is a company fairly big all over the country, really. I believe it provides uniforms and that sort of thing. And it has 2 managers, and they hire this woman by the name of Catherine Jimenez. And because a dispute arises, Jimenez takes them into St. Louis County Court, and the defendants here contend the trial court made a mistake in failing to compel arbitration. Now, I should point out that this is a very common tactic nationally with employees. When you're a big corporation, you get them to sign an agreement when they start work saying, okay, we will grant you employment, but you have to sign this arbitration agreement, which says that, if for any reason we have a dispute later on, you can't sue us, you have to take it into an arbitration panel. And oftentimes these arbitration panels are kind of unreasonably designed. For example, the NFL at one point had an arbitration agreement which required that a dispute between employees of a NFL franchise and the NFL franchise itself had to take it to arbitration in front of the NFL commissioner. Well, gosh, since it's the NFL organizations that pay the commissioner's salary, it seems pretty easy to figure out who he would be most inclined to view the case in a favorable light for. Not all arbitration agreements are bad. Some of them provide for neutral arbitrators. Some of them use different arbitration services. But the bottom line is, and this is just the truth, it's not an employee-friendly kind of thing. So as a result, lawyers who practice in the area of employment law tend to be very skittish of employment agreements that have arbitration clauses and do their best to get around them. And that's essentially what happens here. So the error that they say they made was that the parties' mutual promises to arbitrate arising out of the employment relationship provided consideration, and that their offer to provide her with new or future at-will employment provided some kind of consideration, and that the agreement wasn't unconscionable. Well, when they took this to the court in 2011, in 2013, they filed a motion to compel Jimenez to arbitrate her claims. Now, there's a big agreement that goes through a number of different things. There are two parts of this agreement that are relevant. Section 8 says that disputes between employee and employer concerning whether either party at any time violated any duty, right, law, regulation, public policy, or provision of this agreement that cannot be resolved in good faith must be resolved through impartial and confidential arbitration. So Section 8 says that both Cintas and Jimenez must arbitrate any unresolved claims for damages as well as reasonable costs and attorney's fees caused by the other party's violation of any agreement of this provision or any law, regulation, or public policy. Now, what that agreement does, of course, is it provides then for attorney's fees if you lose your employment claim, which most of the time state law does not allow. But again, if an employee doesn't know what the law is or doesn't have a lawyer who's up on what's going on, this can be a problem. But it says all of these claims are going to be arbitrated, including discrimination in employment, Title VII of the Civil Rights Act, Americans with Disabilities Act, Employee Retirement Income Security Act, all these different acts. But then it says claims for a declaratory judgment or injunctive relief concerning any provision of Section 4 of this agreement is not subject to arbitration. So those are excluded. So when you get down to Section 4, employees' acknowledgments and covenants, employer may apply to any court of competent jurisdiction for a temporary restraining order, preliminary injunction, or other injunctive relief to enforce employees' compliance with obligations, acknowledgments, and covenants in Section 4. So do you see what they've done here? They've said, if you have a problem with us, you have to take it to arbitration. And of course, in an arbitration, the employee picks an arbitrator who she probably doesn't know from Adam, and the employer picks an arbitrator who they probably do know quite well, and then they proceed to arbitration with those two people picking a third arbitrator. They have to, the employee has to arbitrate everything, but the employer says, no. Pay attention now. If you violate your covenants, if you reveal any of our trade secrets, or if you take our customer list or something like that, oh, no. We can sue you on the spot and haul you into court and get an injunction to prevent you from doing anything like that. This is really interesting because one of the concepts of the doctrine of consideration, particularly when you have a bilateral contract, and in the law, what a bilateral contract is two parties exchanging promises. For example, an employer promises at the end of a school term to pay the tuition of an employee, and the employee promises to obtain at least a grade point average of 3.0 in order to get their tuition paid. These are two things to be performed in the future, and they are promises. So if either party doesn't comply, in other words, if the employer doesn't pay for the education, if the employee doesn't get a 3.0, well, then there's no consideration and there's no contract, and it can't be enforced. That's the way a bilateral contract is supposed to work because both parties are mutually obligated. If the other party performs, you have to perform, and that's just the way it's supposed to work. But in this case, the court is going to look at these promises and say, I'm not sure this makes the grade. So at the trial court level, the court held an evidentiary hearing and denied defendant's motion to compel. In its order, the court declined to address whether Jimenez had actually signed the agreement because she claimed she didn't, whether she'd reviewed it or received a copy of it, concluding instead that it need not address these matters since the third element necessary to create a binding contract, bargained for consideration, is dispositive of this matter. The court stated the parties had agreed that Jimenez was an at-will employee. Now that's important because in an at-will employment relationship, you can quit or be fired at any time. So the court stated that the parties had agreed that Jimenez was an at-will employee. It then concluded the agreement to arbitrate lacked consideration because there cannot be sufficient consideration given in an employment contract with an at-will employee such as to consummate a binding contract to arbitrate any dispute between parties. The court further held that even if the arbitration agreement contained consideration, it was unenforceable because its terms were unconscionable. So the defendants appealed. Now, the court points out that whether arbitration can be compelled under the terms of an employment agreement is a question of contract law that they review de novo, meaning they look at it without relying on the court's opinion or the court's analysis. They do their own analysis. This is a standard of review that is employed in almost all contract cases. The only difference is if there are disputed facts, if there are facts that have to be decided by an evidentiary hearing where people come in and testify, then the trial court is given deference for being able to view the testimony and decide whether or not somebody's telling the truth or give credence to it. But the actual legal determination, whether there is consideration, whether it's a valid employment agreement, whether it's a valid arbitration agreement, those are all legal rulings that the court makes on its own motion and that it reviews de novo, meaning brand new. The party seeking to compel arbitration has the burden of proving the existence of a valid and enforceable arbitration agreement. So, in their first 2 points, defendants argued that the parties formed a valid arbitration agreement providing 2 separate types of consideration: Cintas's offer of new or future at-will employment, and 2, Cintas and Jimenez's mutual promises to arbitrate. The court goes down to the standards for what is an arbitration agreement. An arbitration is a matter of contract, and parties will be compelled to arbitrate only if the arbitration agreement satisfies the essential elements of a valid contract. To resolve disputes concerning the validity of a contract, we apply the usual rules of state contract law and canons of contract interpretation. And so they look at this and they say legal consideration is essential for the formation of any contract, including one for arbitration. Consideration is created either by a promise to do or refrain from doing something, or transfer or giving up something of value to the other party. The at-will employment does not constitute consideration. And that is a staple of Missouri law. If this is something that was tried in the, I'd say the mid-90s, companies would come to their employees and say, okay, starting on September 1st, you all, in order to continue working here, you have to sign this arbitration agreement, and your consideration is you're going to sign the agreement, and our consideration is we're going to continue to employ you. Now, of course, nobody ever talks about the elephant in the room, about what's going to happen if none of the people sign the agreement. Are they going to close the factory? I don't think so. But under Missouri law, at-will employees, they do not provide consideration to support an arbitration agreement. Now, if you have a contractual employee, in other words, I'm gonna contract with you to perform 14 hours worth of service at $15 an hour. Well, that's a different situation. Now you've got a contract and you can have mutual consideration. But where you are at will and can be fired at any time, it's an illusory form of consideration. They cite to a case involving the Kansas City Chiefs holding an offer of continued at-will employment did not constitute consideration for the arbitration agreement. All of these cases hold that essentially you have to have something more than at-will employment to support an arbitration agreement. So then we go down to the mutual promises to arbitrate. The parties are not mutually obligated to arbitrate all of their claims. Defendants also contend that consideration is provided by the arbitration provisions promises to arbitrate disputes. Jimenez responds, however, that the agreement to arbitrate is not mutual and reciprocal, and it is therefore devoid of consideration because it exempts Cintas from arbitrating those claims it is most likely to bring against Jimenez, while she remains bound to arbitrate those claims that she is most likely to bring against Cintas. Where there is no consideration other than the parties' mutual promises, the agreement is commonly referred to as a bilateral contract. Valid consideration supporting a bilateral contract, unlike a unilateral contract, rests solely on whether the parties' promises to each other are mutually binding. If a contract contains mutual promises such that a legal duty or liability is imposed on each party as a promisor to the other party as a promise, the contract is a bilateral contract supported by sufficient consideration. Consequently, in Missouri, a bilateral contract requires mutuality of obligation as essential to the formation of a valid contract. A promise is not good consideration unless there's mutuality of obligation. And mutuality of obligation means an obligation rests on each party to do or to permit to be done something in consideration of an act or promise of the other that is neither the party bound unless both are bound. So if you can't have both parties bound, there is no contract here, and that's essentially what the court decided. You can see, looking at this, how easy it is for consideration to really be difficult to prove in a contract case. And this is often overlooked by lawyers. One of the reasons it's come about in employment cases is because of these arbitration agreements, and there is a need to have somebody sign a contract to arbitrate. If there's no contract, there's no arbitration agreement. And in order to get the consideration necessary, there has to be mutuality of obligation, and a lot of times under Missouri law, it simply is not found. Now, other states don't have this rule. I'll tell you that right up front. I think they should. I think all states should have this rule. But a lot of them do not view it in this manner. And as a result, if you're in a different state, this rule most likely does not apply to you, and you'd need to check with an attorney in your jurisdiction to find out. Now, there are a number of cases that deal with consideration, and different states have different rules. If you are in a state, for example, that didn't have this rule, you could certainly use the argument that the Missouri courts use, and you could use the authority from Missouri courts to argue that. But if the state had already decided that at the Supreme Court level, you would have to go to the Supreme Court to get them to change the law, which is always a really uphill battle, and a lot of times people don't want to fight that battle because it's costly, time-consuming, and it often is futile as well. A lot of it depends on whether the judiciary is interested in the equities of the situation. Missouri law is unique, I think, in some ways in how well it protects employees in that context. And that's because if the state grants you a right to sue your employer for employment discrimination, there should not be a method through which your employer can work around that law so that you go to a private court with private judges who have the authority to do what a jury would do normally in a court case. And oftentimes the awards, even if there is an award for discrimination, it tends to be greatly reduced in those cases. So that's my take on both employment law and the issue of consideration, which is how this often comes up. Consideration can best be viewed as mutuality of obligation. Both parties have a duty to the other party, and the agreement rests on that mutual duty. So we'll talk a little bit more about some of these other elements in videos to come. Thank you very much for watching, and if you have the opportunity today, do something kind for someone. If you have any questions, drop them in an email to me. Otherwise, catch me down here at the beach tomorrow. See you then. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.